First case on this morning's docket, case number 117344, Jaylene Lambert et al. V. Johnny Peterson, MD et al.
Your Honors, this case involves a medical malpractice claim where a very healthy individual by the name of Stanley Novak was admitted for double knee replacement, and due to various issues related to that surgery, Mr. Novak ended up passing away. And after that, my client, Jaylene Lambert, opened an estate on behalf of Mr. Novak, and a personal injury suit was filed. That personal injury suit was e-filed electronically, as is preferred by the state of Kansas, and it was e-filed on the date of the last date of the statute of limitations, around noon, and subsequently the next day was rejected by the clerk, indicating that in entering the parties there was a error in the clerk. Then it was refiled, and after that was accepted when the acceptance notice was the following date. I do request, Your Honor, that I reserve 4 minutes in rebuttal time.
4 minutes is granted.
Yes, please. Your Honors, this case is a case of first impression in the state of Kansas. I understood in the notice regarding this argument that you wanted us to discuss essentially the authorities that we were relying on, and therefore I've worked very hard to prepare for that. In my authorities, because there is no case law in the state of Kansas, I've identified 2 separate cases, one out of the state of Iowa, which of course is very close to Kansas, and one out of the state of Missouri. Now, Missouri does have a statute that allows, and is somewhat more clear, but allows that the date of filing is the date that it is filed, even if there are some
Did you present these case citations to the district court when you were presenting your?
I did not.
Because I note that the district court was somewhat frustrated by the lack of authority in your position, and now you've found some and you want us to look at that authority. Is that right?
That's correct, Your Honor. And at the time, obviously, there was no Kansas authority, and there still is no Kansas authority.
But these cases existed at the time.
These cases did exist at the time. And based on the Iowa case, which is very similar, there was a clerical, they wanted them to add an address in the civil information sheet. In our case in particular, they came back and said that it was a duplicate parties, which didn't make sense to me because I had entered the Jaylene Lambert as the plaintiff and then her as the administrator of the estate, which is clearly 2 separate parties. The clerk of Wyandotte County wanted that to only be entered as one party, which is not consistent with any other filing that I would ever do, because when it's 2 separate entities, 2 separate parties, I've always identified them in any filing as 2 separate entities, and that way they are properly entered in the court's record.
And as I understand your written argument anyway, your assertion is that the clerk had no authority because there was no rule that required you to do it any other way, so that the clerk had no authority to reject the filing?
Well, I think that the clerk was making a correction that and a big part of it is whether the clerk had the authority to reject it and then end up causing it to be filed subsequently to a later date, or whether or not the rejection was simply, we would have entered it a different way. I mean, in any other situation, when you're entering it on a civil information sheet, it would have been on the sheet, and the clerk could have chosen to include it or not include it. In this case, the clerk went back and had me make that correction, but there was nothing ever within the judicial guidelines or anything within the e-filing system that would suggest that when you have 2 separate parties, as in the estate and the individual, that they wouldn't be identified both entered into any system, because I believe that that's what had to be done, and that is why it was done that way. In addition, there was no guideline. The rules in the state of Kansas have to do with the fact of e-filing can go through midnight. I wasn't notified until the next day. I promptly made the correction, and then the following day is when I got notice that it was accepted, and then they backdated it. And in the e-filing rules, it says that the transmission is accepted upon completion of the transmission. Now, that is very vague in many ways, because I transmitted it on the correct day at 12/11. I provided that as an exhibit, and that is an exhibit that is in part of the appeal. It was then refiled the next day, and the clerk on the following day sent back an acceptance, and it was e-filed at approximately 1 o'clock, re-filed approximately 1 o'clock on Wednesday, and the clerk came back on Thursday and accepted it as of 4:56 on Wednesday, which isn't when the transmission was completed. It's not even at that point when it was filed. And the problem is it creates many inconsistencies. Now,
Excuse me, counsel, for ease of reference, could you just refer to it as day 1, day 2, day 3?
Yes, Your Honor, I can change that. And so as it becomes a problem of different systems, different counties have different guidelines, we need consistency, and we don't have that consistency anywhere within the state. And this was clearly an issue as it related to the filing of this case in Wyandotte County. The part, and I want to refer back to what appellees have relied on. The appellees in their brief indicated that the electronic filing, that the district courts have to accept electronic filing. When I read that, I understood they were trying to say that everything was based on acceptance. However, that rule simply says that they have to allow electronic filing. The word accept in that particular portion of their brief is actually referring to the requirement that all of the district courts allow electronic filing. In addition, they subsequently said that if the electronic filing system is down, then I have to take a hard copy to the courthouse. The electronic filing system wasn't down. It wasn't inaccessible. It wasn't unavailable. And therefore, that portion of what they're trying to rely upon, suggesting that that was a requirement at that point, again, does not apply. The electronic filing system was up. It was running. I did file it within the time frame that was necessary. The notification that it, and I watched, honestly, I watched the system to be sure that the acceptance came through, and in case there had been a flaw, but there was no flaw with the pleadings. There was no flaw with form of payment. There was no flaw that could be considered an issue that should delay any processing of this claim. The only flaw was that in Wyandotte County, through their electronic filing system, they wanted those two entities identified as one. And I, obviously, in no other case, and I don't know, I mean, other counties have accepted. I haven't filed this type of claim in another county other than Johnson County, and at that point it would have been identified as two separate parties within the filing civil information sheet.
And the information we have about all of those facts is basically your representations to the court. Are there any affidavits or any other form of evidence?
Well, you do have the copies of the confirmations, and all of those confirmations are very consistent with what I have presented. In fact, the confirmations each were dated on each of the dates. On day 1, you have the confirmation indicating that it was received, that the notice was received. And on day 2, you have the confirmation that it was rejected. On day 2, you were also provided the confirmation that it was refiled. And then on day 3, you got the confirmation from the clerk's office, which is not just my affirmation, those are records from the clerk's e-filing system, that it at that point had been accepted because, and it still took additional time. I feel that at this point in time, it just becomes, it becomes a very problematic situation when each county has their own, each clerk's office is not subject to just simply, if there's a clerical or a minor issue, which there was never an issue, I was never suggested that I hadn't signed the document, that the document hadn't had language that was necessary, that there wasn't a certificate of service, that there was actually a failure with the pleading. The only issue had to do with the documentation as supported by the clerk's office. So yes, it was my communications with the clerk's office that is what happened, and then that was supported by the exhibits that were admitted at that time and attached here too, supporting the time frame and everything that was done. And that's pretty much where we were at that time, and I believe where we are at this time, that is exactly what happened. I understand that the appellees also complained about hearsay, but at the trial they didn't make any hearsay objection. And so I believe any objection to that was waived, because at the time of trial there was never a hearsay objection, there was never an objection to the exhibits. It was simply that that's what ended up happening. And I believe at this time that should be, that those arguments on their behalf should be disregarded. As this court knows, in order to preserve an issue for appeal, you have to object, and they didn't object to hearsay, and they didn't object to the documents that were admitted, and they didn't object to the statements that were provided to the court, which were consistently supported by the documentation that was provided to the court at that time. I do believe at this time that it is appropriate for this court to find that the language of the administrative order stating that is effective upon transmission should be the controlling factor. I believe this court has authority and to clarify rules. I believe that this court is pretty much the only place at this point in time that you can get any consistency, because it is not consistent throughout the state of Kansas. And I don't believe that it is fair for it not to be consistent throughout the state of Kansas, whereby it becomes essentially a judicial determination whether or not the judge chooses to accept or not accept. And therefore, it also can come down to whether or not the judge finds it appropriate for that case to be there. This judge clearly on the record made a statement that he didn't like the fact that the case had been filed in Wyandotte County, although there was a doctor that has offices in Wyandotte County, and we validly had the opportunity and jurisdiction to file it in Wyandotte County. He was not happy that it was filed in Wyandotte County, and therefore I think that can paint a judge's view and consideration in whether or not he wants to allow it to be retroactive and filed on the date of filing or not. And I think that should be considered.
Does that conclude your presentation?
Other than my rebuttal, yes.
All right. Do we have any more questions? Thank you, counsel.
May it please the court, Jeff Brown on behalf of Appalese. As we have shared issues amongst the Appalese, I will be making the argument for all. Before we dive into the issue of the electronic filing and the issues that were addressed by counsel on that topic, I would be remiss if I didn't address that a secondary issue that is probably prominent for several of the defendants, specifically defendants Manolo, Norton, and Peterson, is that there also was absolutely no evidence in the file or in the record of appeal that there was ever any service of process that was made upon these defendants.
That was never ruled on by the district court, though, was it?
Well, here's the relevance, Your Honor, if I could point that out. There was no evidence that's been presented. And in order for there to be an action commenced under the Rules of Civil Procedure and under KSA 62.3.203, the petition has to be filed. That's the issue we're also addressing. But then there also has to be service within 90 days. There's no evidence in the record on appeal. There's no reason to address that issue in that, as to these defendants, there was absolutely no service of process either attempted or purported.
How do we do that as an appellate court if the district court hasn't made any factual determinations regarding that?
There's no need to make a determination on the factual point because there's no evidence on the record of appeal.
But that requires a finding by us that there is no evidence, and we have the record. We don't even know necessarily if we have a complete record. related to that issue.
Well, our position obviously is the record is complete and it shows that there's no return of service and no attempt or purport of service on these defendants. Therefore, the two concomitant factors required for commencing an action being the filing and service within 90 days did not occur. But I understand the court's concern on that issue. Addressing the primary issue that we're here to deal with, and that is whether or not the attempt on day one by plaintiff to obtain filing of this action was appropriate and is somehow excused for the failure. I think the court pointed out the primary issue with this is plaintiff has not preserved in any way, shape, or form a record of what was actually done other than statements of counsel. And as the court will know, statements of counsel are not evidence. She did not prepare an affidavit. She did not obtain an affidavit from the clerk. She didn't have an affidavit from anyone in her office saying that this is what occurred. So all we know is that something was attempted to be filed on day one by plaintiff's counsel. What that was, we don't know. Whether it was the petition in this action, we don't know. Whether it was a petition that was inadvertently from another action that she attempted to file for this action, we don't know. We have no idea what it was. It could have been a correspondence. It could have been anything. What we do know is that she received on day two notice from the court that it was rejected because the parties that are on the cover sheet that are required to be electronically submitted did not match with whatever was filed. There's been representations about what that meant and what occurred, but there simply is no evidence for this court to rule on, no facts that are presented that would allow us to know what that attempt was.
What is your response to the argument that you waived that or failed to preserve that at least before the district court?
Well, there's two issues to that. One, as to several of the defendants, my clients included, we filed a motion to dismiss that was argued, it was filed and then argued before the court with no responsive pleading from plaintiff, nor was there any appearance at the arguments. That motion was granted orally at that time. We came back later with the other defendants to argue the issue of whether or not the journal entry was appropriately created. Plaintiff had subsequently objected to the journal entry. At that hearing, plaintiff for the first time, even though in her response to the other appellee's motions to dismiss did not include any exhibits or affidavits or documents, she brought with her to the oral argument three pieces of paper, which were purportedly the e-filings that she attempted in this case. We objected at that time on the record, and if you review the court's transcript for that hearing, you will see objection by counsel because this was not a document that was provided to us. We didn't know where it came from or its source. So we clearly objected as to foundation and as to hearsay. So that is very clearly preserved. Taking that in mind,
Counsel, to follow up on your presentation, as I understand it, you're saying that we just don't know what was filed on day one.
right.
But we do know from the clerk's submission on day two that it had something to do with parties not matching up.
Right.
So my question is, opposing counsel has embraced the Iowa court's holding, and they talk about minor errors in the Jacobs case. So I need to ask you, even if we apply the Iowa Jacobs case to these facts, is it your position that we don't know the magnitude of the error, or is that something different?
No, that's it exactly, Your Honor. We don't know what the nature of the error was. We don't know if it was a completely incorrect petition where the information for the cover sheet that she filled out electronically didn't match. In this day and age of transmission of electronic documents, it's certainly conceivable that she may have inadvertently attached the wrong file.
What difference does that make, though? Let's assume, assume it's the wrong document. Wholly different pleading in a different lawsuit, okay? If the grounds for the clerk to reject it would be outside the clerk's authority to reject the pleading, then all we have to say is that much. The document comes in, and then you all get to argue about whether it was good enough. What's the harm in that?
Well, there's several things. The harm, number one, is the harm is the difference between there being an action brought against the
But you
clients
can
in this
argue
case.
that later.
Right. The statute of limitations, obviously, is the nature of the primary prejudice to the defendants.
There's
This
no
is-
prejudice because you're going to get to argue about whether this was, because
Okay.
this is just, she tried to file this. And so the statute of limitations argument's still there because that's not starting a lawsuit. I mean, there's nothing that you lose if we just focus on whether the clerk had the authority to reject whatever it is that she tried to put into the system.
And our position is that the clerk clearly does have that authority to reject pleadings. It's provided by the rules promulgated by this court, as well as the directives that have been provided by this court in the Administrative Rule 268, as well as local rules, which clearly grants the clerk's authority to reject pleadings that don't comply either to form or to the requirements of that particular court.
Doesn't
you
that
agree
run,
with-
I'm sorry, doesn't that run the risk of a lack of uniformity across the state in terms of which judicial district you try to file something in, that one clerk's got greater discretion to kick something than another clerk, and so you've got a misapplication of the law, or at least an inconsistent application?
Well, Judge, our position in this case is that we can only apply the law as it existed in 2016 when this attempted filing occurred. Certainly, there can be some arguments made as to why there should be legislative initiatives undertaken to create uniformity, or this court to clarify points like this that were potentially left unclear. But as we set in 2016, the court clerk of Wyandotte County clearly had the authority to reject this pleading if it did not comply with the rules. We have Supreme Court
Counsel?
rule.
Counsel,
What
before
rule
you-
did it not comply with,
Yeah.
is my question.
Well, that's the challenge we have as the appellees, Your Honor, is we don't know what she filed. By her failure to preserve this at the district court level and present it to this court as to what exactly she filed, other than representations that she's made that are otherwise unsupported, we don't know what she filed.
I understand that argument. Go ahead, I'm sorry.
No, go ahead.
I understand that argument, that you're unsure what the document was. But as my colleagues have already pointed out, we do know that it was rejected because of this party matching issue, correct? That was what was said in the
Again,
document
that's
from the clerk.
based on a presumption that it was on this matter. We don't, again, we have no
No,
record.
I just want to, that was stated, right, in the document from the clerk, that it had something to do with party matching.
Which has no file number, which only has a date, which we're having to
Okay.
take her word as. I agree that that's what it says. It was rejected for
Okay.
the parties not matching.
So I want to understand where that rule is about the necessity of party matching. Where is that written down?
Supreme Court Rule 123, which dealt with and has been in place for quite some time, dealing with the cover sheet that must be filed with any new petition.
Does it talk about party matching?
It does. You're to clearly identify the parties that are listed in the case. And if the parties that are listed on this cover sheet, which is now with the e-filing system in an electronic version, they have to match what is on the petition. So even if we're to assume and take what she has represented that is wholly unsupported as being true, what we have in this documentation is proof that she did not comply with Supreme Court rule. And the court is clear in the administrative rule that it set forth is that e-file documents must be received and subsequently accepted. Receipt of the pleading is not enough. There has to be actual acceptance of the pleading, and that never occurred. So there was no filing that occurred in this case. And
Excuse me, are you talking about order number 268 now?
yes, Your Honor. And to get some guidance on that, there's a multitude of information and resources this court's provided. One was a PowerPoint that this court put together for the guidance of attorneys when this system was being implemented to help attorneys understand how to use this. We all, when we e-file, we have a term of use that we've agreed to, which says that we've acknowledged and agreed that if we're going to use the e-filing system, which in 2016 in Wyandotte County was still optional, she still could have gone down to this courthouse and filed this document. But if you're going to use this system, you have to understand how the system works. And this PowerPoint provided by the court makes a clear distinction that received is not the same thing as filed. They are two separate terms. Receipt means that something's been provided to the court that may or may not be in compliance with Supreme Court rule or with local rule, which is a requirement by statute for filing. So she may have submitted something, but it is not filed, and it does not act to preserve and prevent the running of the statute of limitations until it is accepted.
Which
Counsel-
touches on just an inherent underlying issue of the authority of a clerk to reject any filing that a party attempts to make, as opposed to that going before a judicial fact finder, the judge, to make the determination that there was an error. What authority, what organic power does a clerk have to reject anything that you would walk into the clerk's office to file?
It says that any filings under KSA 6205 must be filed in accordance with Supreme Court rules. They must follow the rules as
But
to.
is it a clerk that makes the decision it failed to comply, or is it a judge that makes a determination that there's been a violation of a rule?
Well, in this case, the judge was unable to make the determination because there was no record presented to the judge. So what we have is a complete failure by the plaintiff to meet her obligation to rebut the argument presented by defendants that the only filed document that exists was day 2, or actually, it was day 2, which was a day after the expiration of the statute of limitations. So the failing and the lack of information for the judge as the fact finder to potentially address that was lost when she failed to respond to some of the appellee's motions to dismiss, and then failed to present any valid evidence for the court to rule on at the time of the final decision making on this issue. The federal court system and the court in its directive to counsel before argument asked us to look at some specific court decisions from the federal system, and those are enlightening decisions, but the issue with the federal system versus Kansas is in the federal system, Rule 5E specifically states that the clerks of the federal court lack authority to reject a pleading for any reason, that cannot occur. Kansas does not have that correlating rule within 6205. 6205 still grants and still provides that any filing has to be in compliance with the court's rules and local rules.
It
So the
seems
clerk
that-
still has that authority. That is something legislatively that the court may direct the legislature to address. But again, in 2016, the clerks had authority to reject these pleadings.
Well, that seems like you're starting with the presumption that the clerk has the authority unless somebody takes it away by rule.
It is stated in the rules that any filing has to comply with this, and the court in its directives talks about clerks' ability to refuse and reject pleadings, and certainly this court's probably familiar with briefs that don't comply to form, other pleadings that don't comply to form. They don't go to the court for a determination as to whether they comply to form. They're simply rejected, and counsel's advised that your filing is rejected. It has long been the practice in the state of Kansas for clerks to have that autonomy within the confines of the Supreme Court rules and local rules.
Counsel, one of the things you've mentioned repeatedly is we don't know what was filed on day 1.
Yes.
And if this court were to conclude, as at least some of the questions have alluded to, that the clerk has no authority to reject the filing, and so why not just let the filing stand and then you can argue about whether or not it's sufficient? So my question is the practical question. Is that possible? Do you know? Is whatever was filed on day 1, is it sitting somewhere on some server? I don't know the answer, and I'm not sure whether you do, but has anyone endeavored to answer that
Here's
question?
the issue with that, Judge, is the opportunity to do that was at the front end of this case.
Well, I understand you've got procedural problems with my question, but I'm asking the practical reality question. In other words, is it possible? Do you know the answer? Is it sitting somewhere?
Well, I think what could have been determined had she taken immediate action, such as the e-filing system being unavailable, the court does provide for that process where you are to, at your earliest opportunity, seek a leave from the court, a nunc-pro-tunc order, asking to date back your late filing to the date.
I think you're not understanding my question. I'm just asking, and maybe you don't know, and that's fine. Do you know, or do you know if anyone knows, whether what was filed on day 1 currently resides in the e-filing system anymore?
Electronically.
Yeah,
Is
what I
there
was
an
getting-
electronic version of what was filed electronically, or was it did it vanish after it was rejected? I think is
Yes.
the argument.
What I was trying to get to with that position is, had plaintiff's counsel taken immediate action, realizing that her filing was a day late.
Counselor,
There's-
the
there's-
question is, do you know whether a filed document, e-filed document, that's rejected remains somewhere electronically in the system? I think that's a real simple question. Do you know whether it exists or not?
Your Honor, I don't know the answer to that, and it's our position that the burden, once we have a filing that is a day late, the burden shifts to plaintiff to find an excuse or an explanation for why that filing is late. She had an opportunity when this was first filed to go to the clerk to try and ferret this issue out, to gain, if not possible, the digital documentation showing, then certainly some sort of affidavit from the clerk she purportedly talked to, who recounted to her what the issue was with her filing and why it was rejected. That
Is there any
opportunity
reason
was
that
lost.
can't be done now?
Because we're over 2 years past, and there's probably been countless thousands of filings since that time. There is no expectation for a clerk to recall this interaction.
Not on your part, but I mean, in theory, she could still go get an affidavit.
I think
from
the
clerk.
opportunity has been lost, Your Honor, and furthermore, she's
And why
waived
is that?
it.
Why is it lost now?
Because
other
we're
than
2
you
years,
think
we're
that?
2 years out from the time frame, and to expect a clerk to remember a specific conversation is probably a great stretch. And this is not a position that was preserved by the appellant at the trial court level, or argued that she should be given additional time, or that there should be some sort of fundamental fairness that lets her to go search out this issue. She had an opportunity when we presented the filed petition showing that this was a day after the expiration of statute of limitations. The burden shifted to her to present whatever evidence she could to rebut the presumption that this is barred by the statute of limitations. She had the opportunity. Her failure to act on that opportunity does not merit this court sending this back for further investigation, for further discovery. The opportunity was there, it was lost, and it's been waived.
I have one more question before.
Yes, sir.
Yeah, I know you're out of time, but I think earlier my colleague Justice Luker tried to ask you about the source of the clerk's authority,
Yes.
and I'm still a little bit hazy on that. You talked about rule. I had a question also, and you told me party matching is in Rule 123, and all Rule 123 talks about is the fact that a cover sheet's required. It doesn't talk about clerk authority explicitly. The statute you cited doesn't talk about clerk authority specifically. So do you have anything else you want to cite to us that tells us the clerk has authority to make these decisions, as opposed to the issue being raised by counsel and then the court making a judgment?
In terms of the clerk's authority, it is more a matter of practice
That's what I
and
thought you said.
exclusion than specific delegation of rights. However, it has long been, as you
Practice.
undoubtedly remember from your time practice as an attorney, and certainly this court, we see pleadings rejected on a regular basis by the clerks for noncompliance.
That's what I understood you to say, that it was more a matter of practice than of explicit law somewhere.
And certainly all counsel, I think, in the state would probably welcome clarification from the legislature on this issue. But again, all we can do, and all we're doing in this case, is looking to what the law was and what the practices were in 2016. And it clearly was a time when there was allowed to be a rejection of pleadings that did not comply for whatever reason. And again, plaintiff's failure to provide a record for this court as to what she did file is the primary challenge that we're faced with today.
Does that authority have to come from the legislature?
I think this court could probably clarify through its own rules, because the court is obviously overseeing the electronic filing system and has attempted to capture every scenario we can imagine. Certainly the legislative action taken at the federal level was to amend Federal Rule of Civil Procedure 5 that stated clearly that the clerks do not have this authority to reject a pleading, that they can't do it. So I would say legislatively, that's probably, if that is the court's desire, that's a directive given to the legislature, is to take away and make it clear that there is no authority and clerks can no longer reject pleadings for any basis. there any further questions?
I had a procedural question. If I understand the sequence of events, some of the defendants filed motions to dismiss, which were granted.
Yes, Your Honor. That would be defendants Westlake, Manolo, Norton, and Gaddy, and Welch. That was not a contested motion. There was no response filed by plaintiff's counsel, and she failed to appear at the hearing on that issue. We subsequently appeared at the later date in conjunction with the other defendants who had later filed motions. The purpose of our appearance at that hearing was simply to clarify the submitted journal entry from the prior hearing.
So the second hearing was not a relitigation of the earlier order to dismiss. You
No,
were
Your
there
Honor.
in more of a advisory capacity.
It was, and in fact, in my statements, if you look at the transcript of the hearing, I made it clear several times that I was there simply to resolve the issue as to the Rule 170 journal entry, as plaintiff had objected to the ruling. The court did ask me a question about the e-filing system, to which I addressed it, but we were not re-arguing the issue. The issue had been dealt with and ruled upon by the trial court at the previous hearing.
So is that order before us? The defendants who were earlier dismissed, is that before us?
I would argue it's not, in that that was not properly preserved. She has lumped everyone together. She's not provided any explanation for her failure to appear at that hearing. There's no evidence that anything is any different. So in our minds, that's been ruled upon, and it's not clear that she preserved that. But we obviously feel that we need to make sure that the court is aware of, well, that's what the ruling was, and that there is a distinguishable point. And this was raised in our briefing as well as an ancillary issue, that this was not, that she had waived any opportunity to address this.
And my next question is, should that order granting the motion to dismiss have been appealed at that time?
The issue, I think, for plaintiff, and I don't want to make her argument, but the issue would be because she was objecting to the journal entry, it would not have triggered her time to appeal. And what the court did, for sake of ease, after ruling and granting the other defendants' motions, rather than do a separate journal entry for our defendants, he just simply said, do one journal entry for all, and then plaintiff appealed from that.
So the journal entry for the clients who were subject to the earlier hearing really wasn't settled until after the second hearing.
That's
the bottom
correct.
line.
Yeah,
because they got combined.
because she objected to the journal entry, yes.
And the notice of
The-
appeal is from that order, from that journal entry.
Yes, Your Honor.
Thank you.
Any further questions?
Do we have any further questions of counsel? I see none. Thank you, counsel.
Thank you.
May it please the court. Council has raised several issues, one of which indicating that they had objected to the documents that were presented at the time of the hearing and admitted by the court that was clearly indicated that those were directly related to that petition. In going back to the transcript and looking at them, their objection was that they didn't get the documents in advance. Their objection was not that these documents were not related to this case, that these documents were hearsay, that they were admissible for any other reason than that. They believe they should have gotten them in advance. And I don't believe that that objection sustains the request that they are trying to enter today as far as preserving whether or not this was hearsay or anything along that lines. In addition, Your Honor, the journal entry there was never a journal entry dismissing the other parties. The only journal entry that was entered in this case had to do with the statute of limitations issue. The court in that journal entry made it very clear that he was not ruling on the other motions and he was not making a finding as it related to the other motions to dismiss. And that is very clear in the journal entry that was appealed to this court.
I'm sorry, would you say that one more time?
There was never a journal entry dismissing the other parties for lack of service. There was never a journal entry entered that would be appealable as it related to that issue at all.
Just
in
the
this
service issue.
Yeah, the service issues, there was never a journal entry entered relating to those issues. And that is a completely different issue in my opinion, as it relates to the electronic filing system and the information that is available through when you log into the electronic filing system. I actually personally log in and e-file all of my personal documents myself. So I'm very familiar with what you actually see. And that was one of the other exhibits that was presented at the date of trial, was that when you look at what you see, there was never a notice of hearing filed relating to any other, there was never any document suggesting, and that is attached as Exhibit 1 to my motion for addition to the records. And that exhibit was also presented to the district court, that nothing was filed in any form that I could look it up through the e-file system, through the court's records. And that is the information that is accessible to attorneys through the e-file system. I obviously believe there's some issues with the e-file system that I keep hoping we're going to be able to get some corrections to, but that is not something that was available to me at the time. And the journal entry that was entered clearly did not rule on that issue, and there is no journal entry associated with that issue. I believe that as it relates to the clerk's authority, the pleading itself was never the issue. The issue had to do with the entry of the parties, and that clerk's office wanting the parties to be entered differently than they had been entered. And that was corrected on the date that it was brought to the attention, and that is clear by the fact of each of the subsequent e-filings, and then the filing where the next day the clerk again accepted the entire case.
Counsel?
Go ahead.
Go ahead. When you said now to the issue of the clerk's authority, I thought you were going to address why the clerk did not have authority to do this, and I didn't hear you say anything about that. So if you could back up and talk about that specifically.
And when it comes right down to it, the clerk is mandated to accept electronic filing, and there is nothing that indicates with any of those mandates that they have the authority to reject an electronic filing, even with a minor, with an issue related to the inputting of the information in the civil information portion of it. She did not reject the pleading. She did not indicate there was an issue with the pleading. The issue became the parties that were entered into the system did not match the pleading, but the pleading, that clerical mistake had to be corrected.
Well, excuse me, order number 268 says e-file documents.
Yes.
Would that not be a cover sheet?
And she could reject the cover sheet from the standpoint of, I guess what it comes down to is, yes, the cover sheet is, and that's the hard part, is that in the past we had a cover sheet that we filled out and then we would e-file. This was electronic inputting of information. This wasn't a document that was downloaded into the system. It was information that was typed in that in the past you would submit a cover sheet, turn it into the clerk's office. The clerk's office would enter that information into the system, and you would go from there. There's no longer an actual cover sheet that is ever actually filed. There's information input to start the system, but there's no actual cover sheet that is ever actually filed. And that's why this kind of becomes somewhat of an issue, because I don't have a document that's labeled cover sheet, because there is no such thing as a cover sheet anymore. Now it's simply inputting the information of the identification of the parties.
I have another question.
Yes.
You heard the question that we asked several times of your opposing counsel about what exists in the electronic system. I mean, is there any, to your knowledge, is there any way to recreate what occurred on day one?
You know, the only
Exactly what occurred, including the pleading that was attempted to be filed.
not that I'm aware of. The only thing that, because basically it goes in and then they either accept or reject it, and then you go back, fix it, and then refile it. So to my knowledge, there's no backup saying this is what was originally filed. Obviously, I think that to support what was originally filed, I did provide the documentation from the confirmation from the clerk's office that is very consistent. I wouldn't have any, and the district court didn't find that this didn't relate to this case.
That doesn't tell us what was originally filed, though. At least that's your opposing counsel's argument.
I understand that is his argument. However,
well, is there anything in the record other than your assertions to the court as to what was filed on day one?
And receipts from the clerk's office that doesn't show exactly what was filed. However, on the other side of it, they didn't object at the time of the hearing that they have no idea what was filed at that time. They didn't make that objection. They didn't make that suggestion at the time of the hearing that they have no idea what was filed on that day and that this didn't relate to that case. There was never any suggestion at the time of the hearing that it didn't relate or that there was any question that whether or not it related. That was conceded to at that time, and I believe at this point any objection to that was waived by not raising that issue at the time of the trial.
Do we have any further questions? All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Clerk will take this matter under advisement.
Thank you.